One, terrific questions. Because we're using this is based on a quantitative study, we, of course, used as controls everything we know from social science literature about what contributes to human rights violations. Okay? So we know that, that low levels of that high levels of poverty contribute to human rights violations. We know that high levels of low levels of democracy contribute. We know that civil war contributes to human rights violations. All of those are entered into the analysis as control variables, and they are still significant. So I want to make clear, I'm not sort of saying human rights prosecutions are the only things that you need to do to improve human rights. It's still very important to improve your democracy, diminish poverty, stop wars. Okay, those are the big drivers of violations. But even controlling for that, we find a statistically significant independent effect of trials. So what I'm saying is we are always on the lookout for those other spurious correlation factors. If something else is causing this, we are always on the lookout for what that factor is, and we try to put it into our analysis. The problem is we don't know what other factor it might be. Okay, we are controlling for time. Okay, so we're using things like that are called simultaneous equation models. I'm not an expert on this. My gifted students are. They tell me that they do get at this time factor. Okay, so we know that it's not that we're looking at factors that come first, and we're looking at outcomes that come later. Okay, but it's possible there is some unknown X factor that's driving both the use of trials and the improvements in human rights. And like I say, people have ideas. We're taking them. A colleague, Robert Cohane, suggested to us, for example, along those lines, he goes, it could be that it's in Latin America, those countries that had an early experience with democracy. And that early democracy experience is driving both the decision to use trials and the human rights improvements. And so we plugged it in and we checked it out, and it's not the case. But the most troubling thing to test is political will for accountability. It could be that political will for accountability is leading both to the decision to hold trials and to improvements in human rights. But I don't know how to begin to measure and document what that is. Okay, and your second question was
in regard to how the number of trials in Latin America.
It's there are a few really big actors here, and they are Argentina, the most in the world, the most trials in the world, Guatemala and Chile. Okay, and but if you look at the database, what's really surprising is how many countries we have in the database. So while there are a few big countries with many, many prosecutions, they even if you take those countries out, you still see the kinds of effects we're seeing. In fact, we pulled all of Latin America out because we were worried that Latin America was driving the results. And even pulling all of Latin America out, we still see these positive results. Okay. Yeah. So they knew it would undermine democracy, so they decided not to do it. Yeah. Is that it? That'd be really hard to test for. What we can say is that there's a lot of countries where people have said, don't dare do that, it will undermine democracy, and countries went ahead anyway, and it didn't undermine democracy. Okay, so I can't tell you whether so what I can say is you remember what the Chileans were saying when Pinochet was in London arrested. They were, it was, like I said, all hell will break loose. There will be a coup in Chile. You're destroying democracy in Chile. Do you remember that? It didn't happen. And so there's a lot of what I call kind of, there's sometimes trial hysteria. People are very afraid that trials will provoke backlash. And remember, it was the same thing when Milosevic was arrested. It was going to be terrible. Awful things were going to happen in the former Yugoslavia. When Charles Taylor was arrested, awful things were going to happen. And all I'm pointing out is, go back and look at each one of them. See what people were saying at the time about what bad things were happening. And then say, those predictions didn't come through. So that would be the main way I would answer you, is that this anxiety is often present. And yet we don't see good evidence in our database, in our analysis. We don't see evidence of examples. Like I say, in Latin America, there was always the fear of coups. And there was one big, really important experience that colored everybody, which was the Argentine coup attempt against Alfonsine. And everyone kind of learned from that you shouldn't have trials because they lead to coups. But there wasn't a coup in Argentina, okay? And Argentine democracy is far stronger today, I would argue, as a result of accountability. And no other attempt to hold a trial in any place in Latin America has led to a successful coup. That starts looking like maybe we're too anxious about it. The prosecutions are being used around other issues. I've been to workshops in Buenos Aires on strategic litigation where they're looking at the environment, they're looking at gender issues. And so the human rights groups that I'm familiar with are actually quite innovative in trying to think about how they can expand the agenda. But those will mainly be civil trials, not criminal trials. And again, I haven't talked about civil trials because it was a huge task just to gather together the data on criminal trials. But there's also the possibility of using civil trials to try to push for improvements in human rights. And I think people thinking about the environment, people thinking about the right to water, perhaps, there's a right to food. There's a famous case in the Indian Supreme Court, for example, about the right to food. And the Indian Supreme Court decided that the Indian Constitution indeed provided for a right to food, and that the Indian state needed to provide a remedy for that, and they actually mandated school lunch programs all throughout India because there was a human right to food that needed to be satisfied. So I think that there are possibilities for using litigation to promote other human rights as well. Well, one thing I should say that this is the political terror scale we're using. It's a 1 to 5 scale. So it's not a very big scale. And actually, moving on a 1 to 5 scale from 2.49 to 3.15 is pretty significant. And if you look, what a 2 and what a 3 means, it really means moving from living in quite a comfortable and safe country to living in a country where you are much more at risk. And so because the scale is small, those differences are bigger than you might think. But again, my co-authors assure me that we've done all statistical significance tests for that. And so they also assure me that they are statistically significant differences in the regressions. One, it's a great question. And what we're seeing, of course, is that we're getting really interesting mixes of law. I'm not sure if I have law students or faculty, but there's really interesting mixes of law going on in these cases. Courts in domestic courts are mainly using domestic criminal law, okay? But they're borrowing very selectively in very interesting ways from international human rights law, from regional human rights law, sometimes from international humanitarian law, in order to get over barriers to prosecution. So, for example, in the Inter-American system, the Inter-American court's decisions about amnesties have been used very effectively. So the problem is you can't prosecute because of an amnesty. But if you can draw on jurisprudence of the Inter-American court, you can say the Inter-American court has found that amnesties are contrary to our obligations under the American Convention of Human Rights. Therefore, we set aside our amnesty, and now we can use our domestic criminal law to prosecute. Or statutes of limitations turn out to be very, very difficult for these cases, right? Because very often the statute of limitations, let's say for kidnapping, has run. And so you're trying to prosecute for disappearance, but your domestic law doesn't have any, there's no statutes against disappearances. You have to use kidnapping statutes, and the statute of limitations is gone. So what these courts are doing is, again, drawing international law that says disappearance is a crime, large-scale disappearance is a crime against humanity. Crimes against humanity are not subject to statutes of limitations. Okay, we pull away our statute of limitations, and then they may be using their domestic criminal law to convict on kidnapping. And now, some courts have been critical of that. They've said, I'm sorry, if disappearance doesn't exist in our domestic statutes, it's ex post facto application of the law to all of a sudden say that the statute of limitation doesn't apply because international treaties ratified after the fact call it a crime against humanity. Okay, so there are interesting legal debates at stake here, and there's not simple answers. But the courts, some courts, have been quite innovative in how they're combining law. Yes. Right. First, I should clarify. You know, yes is my answer, but I wouldn't say always it's domestic rather than international because of my point about saying that these are interactive. Okay, so it could be you're getting a domestic trial because there's the vague threat out here that there might be an international trial. Okay, all other things being equal, domestic justice delivered close to home is the best justice, I think. Okay, why? Because you know people are able to provide evidence. Because it's being done in local languages, because the people are familiar with the rules of the legal system, and there are very important examples where it has helped build capacity, but not just build capacity, it's helped build belief in rule of law. So my Argentine colleague, Kathryn Sikkink, has written, I think, a brilliant article about the trials of the juntas in Argentina that she calls the discovery of law. That Argentina, witnessing its leaders put on trial, many Argentines, the essence of rule of law, of course, is that no one is above the law. But the impunity model meant that state officials were always above the law. And so people witnessing that their leaders were not above the law began to think, maybe the law is a tool that one could use. Maybe we should trust the law. Maybe we should try using the law. And so that was her argument, that people not just developed capacity, but they also developed a belief in the utility of law. And as you know, another interactive factor is the International Criminal Court, of course, is involved in helping countries develop capacity so that complementarity is not just a threat, but complementarity is actually a promise that these trials could and should take place domestically. Thanks for that question. The main way it's made me think is I have realized there's a much stronger regional dimension to norm emergence and norm diffusion than I previously thought. And so sort of seeing like this really strong, Latin America phenomena that's going on and seeing that the norm diffused first in the region. And then there was sort of some norm jumping from region to region. I realized we need to, when we're thinking about norm emergence and diffusion, we need to pay more attention to regional dynamics. Or like the Truth Commission norm. Truth Commissions really started in Latin America, Argentina, Chile, El Salvador, the first Truth Commissions. And then those folks are actually invited to South Africa to consult, and the South Africans come up with a quite innovative new form of Truth Commission. And that's the strong diffusion that comes out of South Africa. So, and if I showed you the table about Truth Commissions, you see Africa's very importantly represented among truth commissions, largely because of the South African model. If we looked at lustration or vetting, we'd see the importance of Eastern Europe. And so I'm thinking that I used to think of diffusion happening kind of in a more general sense globally, but I'm thinking now that regions play a much more important role in norm emergence and norm diffusion than I did previously. I'd say it's a more complicated argument than that, because first it's about how moral norms become legal norms. Okay, so but what makes it more complicated is it says there are domestic legal norms, okay, domestic criminal systems that have long said that if someone murders, they should be prosecuted and sent to prison. But there was just this little exception, unless you were a state official, in which case that norm didn't apply. Okay, then but there was kind of a moral norm, which was that really that was wrong. It was wrong that individual state leaders should be able to order, as in Argentina, the disappearance of 10,000 people and be untouchable. And that moral norm was slowly translated into a legal norm. an international legal norm. So there's this really interesting interaction between domestic legal norms, international kind of moral norms, translated into international legal norms. And one of the most interesting questions for me is what's going on in the Americas in the 1970s. Okay? The Inter-American Commission of Human Rights is writing reports about Chile and Argentina after the coups there, and they're sending recommendations back to the governments, and they're saying, and for torture and disappearance and summary execution, you must prosecute with the full extent of the law, the full force of the law. And they're saying, the Inter-American Commission is saying that at a time, the American Convention of Human Rights isn't even up and running yet. It hasn't even gone into effect. They're working under the American Declaration of Human Rights that doesn't say a word about the duty to punish. So, they're like making up things. But they're making up things because they're drawing on domestic criminal law and their moral belief that domestic criminal law should be internationalized. And they want to make it so. And they eventually succeed. So, so you're recognizing pieces of things I've done before, right? So the importance of the activists beyond borders are here, right? So this is the thing that's been most interesting to me about this case in terms of theoretical development, okay? Is norm emergence is the result of these norm entrepreneurs. I just think there's no way around it. The norm emergence comes from the norm entrepreneurship, right? But the changed behavior comes as a result of deterrence, which is a rational issue. State leaders fear punishment, okay? And I said so it's this trying to figure out this mix between norm emergence, where there's these norm entrepreneurs, but changed behavior, which seems to be the result partly of rational decisions. I'm not going to do this because it's not a good career choice, because I see these guys end up in jail. Right? And so one of the ways I'm thinking about it is the individuals capable of violating human rights are powerful security forces and military. And very often, I think these folks benefit greatly from repression. Okay? When they repress others, they take political power, they punish their political opponents, they gain economic wealth. Okay? So human rights violations are not, it's not just, bad people doing evil things. There's a lot of benefits to human rights violators. And in the past, there were lots of benefits and no costs. Okay? I don't think you have to be a die-hard rational choice theorist to think there's something wrong with that scenario. That kind of scenario, lots of benefit, no cost, is going to perpetuate human rights violations. And if we can get a scenario where still there's lots of benefits from human rights violations for these powerful security forces and individuals, but the costs are getting higher, that might help diminish. And so I'm thinking, what's the, we need, sometimes, we need to blend these different explanations to explain the behavior of different actors. And in this case, to explain the behavior of actors who violate rights and who benefit from violating rights, I think the notion that punishment may be necessary. I haven't thought about that, and it's a really interesting point, that the very nature of the types of crimes involved may affect the desired transitional justice solution, right? And so if it's these powerful militaries or security forces that are that are distant, that people may want punishment in those cases, but if it's insurgents and child soldiers who may have come out of your communities who you want to reintegrate, you don't want punishment. I think that's plausible. It would be really worth looking at more. So when I started the chapter in the United States, my first question was like, what are they thinking? You know, we helped draft the torture, we, the United States, helped draft the Torture Convention. We ratified the Torture Convention. We implemented the Torture Convention in domestic law. The Pinochet case established precedent clearly, and then you're going ahead and torturing? You know, because you've got to realize that you can all end up arrested abroad and in prison. You could. It's hypothetically, it's legally, it's legally, not just hypothetically, it's legally totally possible for Donald Rumsfeld to go to prison for this. The documents are there, okay? So my first question was, what are they thinking? When I started doing more research, I realized that at every stage, the Bush administration policymakers were trying to build up their protection from prosecution. So even the things that we initially thought, the torture memos, were just about defining torture. No, the torture memos were also about, remember they said the Geneva Convention doesn't apply. Well, we have something called the War Crimes Act in the United States. It's statutory law that says that people who violate Geneva Conventions can be prosecuted, and in fact, the death penalty exists for it. And so one of the things they were doing by clearly saying Geneva Convention doesn't apply is saying the U.S. War Powers Statute doesn't apply because if Geneva isn't involved, you can't prosecute people for breaking Geneva Conventions. Now, though there's a whole series, if you read the chapter, there's like 4 or 5 moves made by the Bush administration to try to limit their the possibility of prosecuting them domestically. And they've done it so well, it'll be very difficult to prosecute domestically in the United States for a long time. But they haven't, as Pinochet learned, they can't control foreign prosecution. So then you have to, and so then you have things like the CIA officials, 25 CIA officials convicted in Italy in absentia because Italian judicial system permits conviction in absentia for extraordinary rendition. Now, people say, oh, cool, big deal, you know, I mean, you know, they're never going to go to prison. But we already know that most of those people have had to leave the CIA. It's not a good thing to be a CIA agent and not be able to travel, you know. And some of them are actually have suffered quite a few costs. So we know that there have been cases, attempted cases against Rumsfeld and others in France, in Spain, in Germany. To date, they have failed. The German judge, though, said, we're going to give the Americans a chance to try to prosecute themselves before we jump in. So foreign prosecutions of U.S., we know that former President Bush canceled a trip to Switzerland because there was only a fairly minor effort to file a suit against him in Switzerland. He was going to give a big speech. He canceled the trip, he said, for security reasons. So, in fact, we know that U.S. officials associated with the torture policy in the Bush administration, virtually all of them are scheduling their travel very, very carefully, looking at what's going on in terms of domestic prosecutions around torture. I'm not saying that's satisfactory. I think that's unsatisfactory accountability. I'm just saying it's that processes are underway that make it possible that at some point there might be foreign prosecutions. But domestic prosecutions are probably going to have to be civil, not criminal. And there is a civil case, 2 civil cases moving ahead against Rumsfeld right now in U.S. courts. Torture victims, U.S. citizen torture victims tortured in Iraq. And they've finally been allowed to move ahead to the next level. So I think the thing to watch in the United States will be civil cases for damages. Those are not being blocked. They're not blocked as well by all these attempts at impunity, and they may provide some modicum of accountability. No, in fact, the clearest thing we know is that you know, you don't have to prosecute quickly to have an impact, and you don't have to prosecute everyone to have an impact. You can prosecute relatively small numbers, and you can prosecute 10, 12, 20 years after the event, and it can still make a difference. We haven't specifically compared fast versus slow. That's something you could do. We're just now recoding our database to get some things like we're getting, we didn't originally look at the level of the official who was prosecuted. So now we divided into high level versus low level, and we want to ask whether the prosecution of high-level officials makes more of an impact than prosecution of low-level officials. We're now looking at convictions, how many people are convicted versus dismissed, and do convictions make a bigger impact? And so we're continuing to work with refining what we know about impact. Right. Well, I think I've already said that we do know there's some things that improve, ending war, in fact, improves human rights. We know that. And that any civil wars. And so the importance of prosecutions is that compared to all the other things we know that promote human rights, ending war, enhancing democracy, diminishing poverty, diminishing inequality, prosecutions are actually relatively easy and inexpensive. To move a country out of poverty is a huge undertaking, as you all know, and not likely to happen quickly or easily. And so prosecution might be a quicker thing, a policy action that's really available to governments to do in the short term, which is why. In terms of military intervention to promote democracy or human rights, my feeling is if we know that the single biggest factor correlated with human rights violations is civil war, that any decision to promote human rights using war is fraught with danger, because it's very likely it's going to initially worsen the situation, at least. And so my feeling is that, again, prosecutions, like, for example, the threat of prosecutions isn't going to help in Syria today, as you can imagine. Whenever you have governments deeply implicating human rights violations, they're not going to stop violating rights because they're afraid of prosecution. Okay? So it doesn't offer a magic bullet for Syria. But I would just have a real note of caution that we do know that the single biggest factor correlated with human rights violation is civil war. Anything that exacerbates war initially is going to exacerbate human rights violations. So you've got to believe that it's so important that you're willing to take that all the initial problems that war creates for human rights as a risk. I've written a whole book on the topic called Mixed Signals, and just what I'll say is this. The United States government has both contributed to repression in Latin America in a series of clear cases, Chile 73, Guatemala 1954. There are other examples, many during the Carter administration, where U.S. policy actually helped improve things, Argentina, for example, Uruguay. And so the question not is what does, the question is what does the United States do? Does it act to promote human rights? Does it act to protect prisoners? Does it act to stop torture? Or does it act to promote torture, promote coups, et cetera? And the crucial issue is how to change U.S. policy so that U.S. policy is genuinely promoting human rights rather than exacerbating the violations. Well, so I'm also coming out with a new edited volume with Thomas Riese and Stephen Ropp, and it's called From Commitment to Compliance. And we're really rethinking, the whole issue of how do you get to compliance. And what we're saying is that internalization, and the U.S. case has made me really think about this. You think things are internalized and they're not. Right? You wouldn't think that today we would be having a debate in the United States about torture. You really wouldn't think that in the Republican debates that the various candidates are vying with one another to, it's so it's you get these huge backtrack kinds of questions that make you realize that internalization is a very, very far off goal for most of these norms. And we have to rely not just on internalization, we have to rely on law and other factors to help move us towards compliance. And full compliance with human rights is a long, very, very long-term project. Anyone who studies law and politics knows that, law is not without politics. And this notion of a realm of law that's apolitical, it's just, we know that just doesn't exist. What's interesting, though, is that the realm of law has to have a different politics. And so the Security Council is a political body. when the Security Council refers to the ICC, it's going to be a political decision. No one should be surprised about that. Okay? The ICC is a legal body. That doesn't mean it's not political, but it means the politics within the ICC have to be different. And so there's people who say, oh, you know, Joseph Kony is right. Let's just get the ICC to drop that accusation against him. Well, that's the kind of politics that doesn't really work within the ICC. You can't say, oh, we made a mistake. Sorry about that one. Drop it. You know? And so I just think we should not be surprised that political bodies like the Security Council are political when they act in the area of law, but know that those kind of arguments that carry weight in the Security Council might not carry weight within the ICC. So when I'm using a scale, the trial data I built, but the dependent variable, which is the repression data, I didn't build. I'm using a repression data that from existing databases. So as I said, includes torture, summary execution, disappearance. Increasingly, rape will sometimes be coded within the torture. But that's a pretty recent development. So any early coding of torture would never have included violence against women. And we do not have good data on violence against women. I could not do what I'm doing using data on violence against women because it's not good enough. And this brings up an issue with all the human rights data. We know more today about human rights than we knew in the past. And so sometimes it makes it look like things are getting worse when actually we have more information. And the violence against women issue is very much there. You know, it would seem that there's much more rape in the world today than ever before. Most of us don't believe that's the case. Most of us think we care more about rape, we document rape, and so we finally start having some good data on rape. But I'm not going to. I don't have a 20-year database on violence against women, and it'll take a long time before there's a reliable 20-year database on violence against women that we can actually see trend changes. And so I don't think we can do that research right now. I believe that some of the cases against Baltasar Garzón are a form of political persecution. And in particular, the case that was filed against him for ordering the exhumation of mass graves from the Civil War is a kind of political persecution. The case was filed by a right-wing fascist group in Spain, and the idea was to try to silence him or try to stop him. There's, of course, as you know, the 3 cases filed against him, and one of them is not a frivolous case. It's the case of wiretapping. That's a legitimate concern. That's legitimate for the Spanish judicial system to ask about and to hold judges accountable for ordering practices like wiretapping that can infringe on the rights of citizens. I believe that the penalty was too severe. It's very surprising to me that a judge can be separated from his job for 11 years for ordering a wiretap, which is something that judges in many societies are permitted to do in certain national security kinds of cases. And so I believe that it was a legitimate case, but that perhaps the penalty was severe, and the very severe penalty may have been a form of persecution of him for his actions against many sectors in Spain. Okay, so Garzón has made lots of enemies in Spain.
So you don't think that it represents a regression in the flow that you were talking about of law?
I believe that this Justice Cascade does not depend on a single handful of people. Baltasar Garzón played a crucial role at a crucial time, but the Justice Cascade does not depend on Baltasar Garzón. As I pointed out, there's all of these important domestic prosecutions. The domestic prosecutions are being brought forward by lawyers and activists around the world to their own domestic courts and judges. And so it's a very decentralized system, and it won't be set back by what happens to Garzón.